This is our last video on Model Rule 8.4G, and we've been talking about a very new ABA ethics opinion, formal opinion 493 that came out in July of 2020, clarifying the purpose, scope, and application of Rule 8.4G. As a quick reminder to my students, there's a video before this you really should watch. 8.4G was added to 8.4 by the ABA in 2016. So some of your older course materials or ethics materials or MPRE materials might not cover it, but now it's been several years and the ABA is starting to clarify and, to be honest, have sort of amplified or intensified the rule. And also the rule has been litigated and upheld by the courts. So I really encourage my students, of all the ABA ethics opinions that we kind of have, and obviously you can see there's 493 of them. You don't have to read all 493 for my class, but this is one of the ones it's what you should read because it's so recent and it's very well done. It surveys recent disciplinary actions, gives examples of things that lawyers are doing that violate the rule, talks about some of the case law with constitutional challenges to it, clarifies some of the definitions really helpfully. And this is a very timely issue for this present moment in our society. And so I would urge my students to be familiar with this, not only for testing purposes, but to assimilate the values of 8.4G into your character and into your practice of law, that this is about fundamentally treating people respectfully and having empathy for people from who are vulnerable members of our society or might be members of groups that that are subject to a lot of persecution and discrimination and harassment and so forth. So let's go back to the slides. And the purpose for this video is that this is one of the rare ABA ethics opinions that gives hypotheticals, sort of Q&A style. And when they do this, they usually give 5, and they're so clear, they're very tempting to turn into test questions, not only for your professor, but for the MPRE, the people writing questions for the MPRE. So I'm going through each of them just so you've seen them before in case you see them again on a final exam or on the MPRE. Example 1, a religious organization challenges on First Amendment grounds a local ordinance that requires all schools to provide gender-neutral restroom and locker room facilities. This is a real thing, by the way. Churches and religious schools and religious publishers and campgrounds have brought civil rights challenges to the gender-neutral restroom laws and ordinances, including here in Houston, where I teach. Would a lawyer who accepted the representation of the religious organization violate 8.4G? Answer, no, no. This situation does not involve the type of conduct covered by Rule 8.4G. The black letter text underscores this by explaining that the paragraph does not limit the ability of a lawyer to accept, decline, or withdraw from a representation in accordance with Rule 1.16. And so the fact that you are representing someone who is saying, we don't think this new civil rights movement should apply to us, or we're worried about it, and we don't need to accommodate or be inclusive of that particular group, it is okay to be a lawyer for that group and to advocate. That's part of the job, right, of lawyers, even if they lose their case. In addition, the provision's next sentence further emphasizes that it does not preclude legitimate advice or advocacy consistent with these rules. Though individuals may disagree with the position the lawyer in the hypothetical would be defending, that would not affect the legitimacy of the representation. And by the way, there have been large national associations of lawyers. The Christian Legal Society, for example, on its website has a long essay criticizing Rule 8.4G and saying this is going to penalize lawyers who represent churches and religious organizations that don't want to have gender-neutral bathrooms or don't want to perform gay marriages and stuff like that. And the rule is very clear that that's not true. And the ABA has now put out an ethics opinion saying those fears are unfounded, that advocacy of a religious group that is challenging a legal requirement will not cause you to be subject to discipline. It's very clear. A lawyer participating as a speaker at a CLE program on affirmative action in higher education expresses the view that rather than using a race-conscious process in admitting African American students to highly ranked colleges and universities, those students would be better off attending lower ranked schools where they would be more likely to excel. And you may have heard this argument before against affirmative action at elite schools, that this actually harms the students they're purportedly helping because they are coming in not as prepared for the rigor of that academic career as their classmates, and they would have been better off going to a lower ranked school and thriving there. So let's say you take this view. I don't agree with that view, but let's say you advocate this view at a CLE or panel discussion or symposium. Does that violate 8.4G? No, no. And the ABA was very clear about this. While a CLE program would fall within comment 3's description of what constitutes conduct related to the practice of law, so the CLE is conduct related to the practice of law, the viewpoint expressed by the lawyer would not violate Rule 8.4G. So if you want to take an unpopular political view about arguing against affirmative action or arguing against prison reform or police reform, or arguing that police should have qualified immunity or something like that, that won't cause you to be subject to discipline. Specifically, the lawyer's remarks, without more, would not constitute conduct that the lawyer knows or reasonably should know is harassment or discrimination on the basis of race. A general point of view, even a controversial one, cannot reasonably be understood as harassment or discrimination contemplated by Rule 8.4G. The fact that others may find the lawyer's expression of social or political views to be inaccurate, offensive, or upsetting is not the type of harm required for a violation. Okay, here's hypothetical number 3. A lawyer is a member of a religious legal organization which advocates on religious grounds for the ability of private employers to terminate or refuse to employ individuals based on their sexual orientation or gender identity. As you know, this is a real thing, right? That there are national associations of lawyers that represent churches and religious organizations and advocate for that those organizations should have a right to have a lot of freedom or be exempt from a lot of non-discrimination laws. Will the lawyer's membership in this legal organization constitute a violation of 8.4G? No. As with the prior hypothetical, 8.4G does not forbid a lawyer's expression of his or her political or social views, whether through membership in an organization or through oral or written commentary. Furthermore, to the extent that such conduct takes the form of pure advocacy, it would not qualify as sufficiently harmful or targeted. Moreover, even though the Supreme Court has now recognized that discrimination based on sexual orientation and gender identity violates Title VII, sorry about the footnote there, it is not a violation of 8.4G to express the view that the decision is wrong. Here's hypothetical number 4. A lawyer serving as an adjunct professor supervising a law student in a law school clinic made repeated comments about the student's appearance and also made unwelcome, non-consensual physical contact of a sexual nature with the student. In other words, the lawyer is an adjunct professor, has a crush on a student, and is making sexual advances or romantic overtures that are unwanted and are really cross the line. Would this conduct violate 8.4G? Of course it would. What's wrong with you? This is an obvious violation and demonstrates the importance of making the scope of the provision broad enough to encompass conduct that may not necessarily fall directly within the context of representation of a client. And so they're trying to say, this isn't just about how you treat clients. If you're a lawyer and you're teaching as an adjunct professor at a law school, then the way you treat your students is also going to apply to come under the purview of 8.4G. Okay, last hypothetical, I promise. 5. A partner and a senior associate in a law firm have been tasked with organizing an orientation program for newly hired associates to familiarize them with firm policies and procedures. During a planning session, the partner remarked that rule number 1 should be never trust a Muslim lawyer. Rule number 2 should be never represent a Muslim client. But of course, we're not allowed to speak the truth around here. Do the partner's remarks violate 8.4G? Yes, that is exactly the type of thing we're talking about. That's completely inappropriate. You're a lawyer. Why are you saying things like that? You shouldn't be saying things like that. That's offensive, right? Even if one assumes that the associate was not Muslim, the comments violate Rule 8.4G. So keep in mind, even if no one in that conversation was part of the group that you're targeting with your offensive remarks, the fact that any of us have to listen to that type of thing, it violates 8.4G. The partner's remarks are discriminatory insofar as they are harmful and manifest bias and prejudice against Muslims. Furthermore, the partner surely knew or reasonably would have known this. And in addition, the fact that the comments may not have been directed at a specific individual would not insulate the lawyer from discipline, though in many instances, the offending conduct will be targeted towards someone who falls within the protected category. If I can just comment on that for a second, most of the disciplinary actions we've seen about this rule and its state law and analogs in recent years have not been about like private conversations where no one from the group was present. It's usually lawyers sending awful emails laced with racial epithets or sexist epithets to judges or opposing counsel or former clients who don't want to pay their fees and things like that. So we're usually not worrying that somebody's listening to every private conversation you have and that every joke or a dumb remark you make is going to get you in trouble, although it could, right? It's clear, and from this hypothetical, it could. Most of the disciplinary actions are because the person has said it directly to someone from the targeted group. Because the remarks were made within the law firm setting, they are related to the practice of law. Moreover, given the supervisory subordinate nature of the partner's relationship to the associate, the remarks may influence how similarly situated firm lawyers treat clients, opposing counsel, and others at the firm who are Muslim. Okay, and that's the end. That concludes our lectures on Model Rule 8.4 and our 2 mini lectures on ABA Formal Ethics Opinion 493.